In this video, I'm going to walk you through the Florida Civil Statute of Limitations for business disputes. And trust me, understanding these deadlines could be the difference between protecting your business and losing everything that you've built. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And I've seen too many business owners lose legitimate claims simply because they didn't understand the clock that started ticking the moment their dispute began. So let's start with the fundamentals. A statute of limitations is essentially a deadline imposed by the law that determines how long you have to file a lawsuit after a dispute arises. Think of it as an expiration date on your right to sue. Once that time passes, even if you have the strongest case in the world, the court will likely dismiss it before you even get your day in front of the judge. Now, you might wonder why these limitations even exist. These are actually good reasons. Evidence deteriorates over time, witnesses' memories fade, and documents get lost. The law recognizes that it's unfair to have the threat of a lawsuit hanging over someone's head indefinitely. But here's what matters to you as a business owner. These deadlines are strict, and Florida courts rarely make exceptions. So let's talk about the most common scenario first: written contracts. In Florida, you have a written contract and the other party breaches it. You generally have about 5 years from the date of the breach to file a lawsuit. Notice I said from the date of the breach, not from when you discovered it or when you decided to do something about it. That's a critical distinction that catches people off guard all the time. Here's a real-world example of how this plays out. Let's say you signed a 3-year service agreement with the vendor back in January of 2020. And they were supposed to make monthly payments to you, and they stopped paying in March of 2021, just a few months later. Your 5-year clock starts ticking in March 2021, which means you have until March 2026 to file the lawsuit. It doesn't matter if you spent months trying to negotiate it or you didn't realize you had a strong case until 2024. That clock is running regardless of what you're doing. Now, what if your agreement wasn't in writing? Maybe you had a handshake deal or an oral agreement. Well, in Florida, oral contracts and contracts not under seal have a shorter statute of limitations of 4 years. Yes, you lose an entire year just because you didn't get it in writing. This is one of many reasons why I always tell business owners to get everything in writing. But I understand that in the real world, deals sometimes happen on a handshake. But the 4-year rule also applies to what Florida calls contracts not under seal. Now, unless you're dealing with very formal or old legal documents, most modern contracts aren't under seal anyway. But it's important to know the distinction. If your written contract doesn't specifically state that it's executed under seal and doesn't have an actual seal on it, it might fall under the 4-year statute of limitations instead of the 5 years. This is an area where the details really matter, and misunderstanding which category your contract falls into could cost you an extra year of time to file a lawsuit. Now, before we continue, if you're finding this information valuable and you want to make sure you never miss crucial legal insights that could protect your business, go ahead and hit that like button and subscribe to the channel. This kind of knowledge is what separates businesses that thrive from those that get caught off guard. Now, let's shift gears and talk about fraud, because business disputes aren't always about contracts. Sometimes you're dealing with fraud, misrepresentation, or other business torts. Now, Florida law gives you 4 years to file a fraud claim, but here's where it gets interesting. The clock starts when you discover the fraud or when you should have discovered it with reasonable diligence. This is called the discovery rule, and it's one of the few areas where Florida law acknowledges that you can't file a lawsuit about something you don't even know about. However, don't get too comfortable with this. The discovery rule does have its limits. Courts will ask whether a reasonable person in your position would have discovered the fraud earlier. Now, if you ignored red flags or didn't investigate suspicious circumstances, you might find yourself out of luck, even if you didn't technically know about the fraud. So it's important to investigate these red flags whenever you see them. Well, what about other business-related torts? If someone interfered with your business relationships, engaged in unfair competition, or committed conversion of your business property, you're generally looking at a 4-year statute of limitations as well. The key is understanding when that clock starts, which isn't always as obvious as you might think. Here's what actually happens when you miss these deadlines, and this is the part that business owners find the most frustrating. Let's say you file a lawsuit 6 months after the statute of limitations expires. The defendant's attorney will file what's called a motion to dismiss based on the statute of limitations. The judge doesn't look at whether you have a good case or whether you were actually wronged. The judge simply looks at the dates, and if your time is up, your case is dismissed. It's that easy. All that money you spent on attorney's fees, all the evidence you gathered, all the stress you endured, it becomes irrelevant. I've seen cases where business owners were owed hundreds of thousands of dollars, had perfect documentation, and had an airtight case, but they waited just a few months too long. The result? Nothing. They got nothing because the law is unforgiving about these deadlines. There's also another practical consideration here. Even if you're within the statute of limitations, waiting until the last minute creates its own set of problems. Evidence disappears, witnesses become unavailable, and frankly, judges and juries look less favorably on someone who waited years to assert their legal rights. If you have a legitimate business dispute, the sooner you address it, the better your chances of success. So what should you do with this information? First, keep detailed records of all your business transactions and agreements, and note the dates when problems arise. If a breach or dispute occurs, mark your calendar with a deadline for filing a lawsuit. Even if you hope to resolve things amicably, knowing your deadline keeps you from negotiating away your legal rights. Second, don't confuse sending demand letters or engaging in settlement negotiations with filing a lawsuit. These activities do not stop the clock from running. The only thing that stops the statute of limitations clock is actually filing a lawsuit in court. I've had clients tell me, but we've been in negotiations for 2 years. Well, that's great, but if those negotiations fail and your deadline has passed, you are out of options. Third, consult with an attorney early. Don't wait until you're approaching the deadline to seek legal advice. An attorney needs time to investigate your claim, gather evidence, and prepare a strong case. Rushing at the last minute leads to mistakes and weaker legal positions. Now, understanding Florida's statute of limitations for business disputes isn't just legal trivia. It's essential protection for your business interests. Whether you're dealing with a 4-year deadline for oral contracts or a 5-year window for written agreements, knowing these timelines ensure you never lose your right to seek justice simply because time ran out. Now, if you found this video helpful, make sure to like and subscribe to the channel for more practical legal insights that every business owner needs to know. Protect your business by staying informed, and remember, when it comes to legal deadlines, it's always better to be early than to be too late. I'm Santiago Cueto, your Florida business attorney. Be sure to watch this next video for more business law insights.